Welcome to this custom-tailored deep dive. We're really thrilled to have you with us today because we are unpacking a scenario that sounds like it's straight out of some bizarre movie.
Well, it really does, yeah.
But it has very real, very complex legal consequences. So imagine this. You decide you want to keep a wild animal on your property,
Right.
and you try to be careful, take precautions, but despite everything, something goes terribly wrong. The jaws clamp down. The immediate question for you is, when the dust settles and those medical bills arrive, who actually pays?
That is the million-dollar question.
And here's where it gets really interesting. What happens if multiple people, including the victim's own family, might actually share some of the fault for what happened?
Exactly. It gets messy fast.
Today, our source material is a fascinating 1983 Kansas Court of Appeals case called Mills v. Smith. Our mission for this deep dive is to dissect the court's reasoning element by element so you can master the mechanics of strict liability and comparative negligence.
And it is great to be here with you. To get you where you need to be, we have a very clear analytical path charted out for this deep dive.
Awesome.
We're going to look at three key doctrines today. First, the strict liability standard for wild animals under the restatement, second of torts, section 507.
Okay.
Second, the application of comparative fault principles, specifically KSA 60-258 to strict liability claims. And finally, the procedural standards for directed verdicts and sufficiency of the evidence.
So let's jump right into the deep end with this first concept. How exactly does Kansas law treat the owners of a wild animal that causes an injury?
Well, the general rule here is strict liability. Because Kansas actually had no prior cases on this back then, the court adopted the traditional rule from the Restatement Second of Torts, Section 507. And this rule breaks down into four explicit elements. First, the defendant is a possessor of a wild animal. Second, harm is done by the animal to another person, their land or chattels. Third, liability applies. Although the possessor has exercised the utmost care to confine the animal or prevent harm. And fourth, the liability is limited to harm that results from a dangerous propensity characteristic of wild animals of that particular class, or a propensity the possessor knows or has reason to know about.
Let's analyze Mills v. Smith. First, what are the legally dispositive facts?
On June 27, 1981, 21-month-old Darcy Lynn Mills visited the Circle 3 ranch with her parents, Vernon and Althea, and her grandparents, the Buckbees.
Okay.
The ranch owners, Ray and Maud Smith, owned a 9-month-old male African lion named Chester, weighing 90 to 100 pounds. Ray Smith actually wrestled the lion, and the adults took pictures. The parents kept Darcy 30 to 50 feet away.
Right.
However, when the mother was briefly distracted, Darcy ran toward her grandparents who were taking a photo with the lion. The lion reared up, knocked Darcy down, grabbed her head in its mouth, and worked its jaw. Yeah, the grandfather had to pull the jaws apart. Darcy suffered a cut requiring 4 stitches, another requiring 3, a scratched cheek, and a puncture wound, with medical bills totaling $248. She sued the Smiths for strict liability.
And what was the core legal issue?
Is the keeper of a wild animal strictly liable for injuries resulting from the animal's dangerous propensities, regardless of the keeper's attempts to exercise care?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the Restatement, Second of Torts, Section 507. The rule has 4 elements. First, possession of a wild animal. Second, harm caused to a person. Third, liability attaches despite the utmost care. Fourth, harm results from a characteristic dangerous propensity of that animal class.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, possession of a wild animal?
The sub-issue here is, did the Smiths possess a wild animal? Applying the facts, the Smiths owned Chester, an African lion, and kept him at their ranch. So the conclusion is that the first element is met.
Understood. Now what about the second element, harm caused?
The sub-issue is, did the animal cause harm to a person? For application, Chester knocked Darcy down and bit her head, resulting in physical wounds and $248 in medical bills, plus a temporary mild adjustment disorder. Conclusion, the second element is definitely met.
And the third element, liability despite utmost care.
The sub-issue is, does it matter if the Smiths tried to be safe? Applying the facts, Mrs. Smith testified she warned the family to keep children away. However, under strict liability, the possessor's level of care to prevent harm is legally irrelevant. The conclusion is that the third element is met, meaning the warning does not absolve strict liability.
Finally, the fourth element, characteristic dangerous propensity.
The sub-issue is whether the bite was a result of a known or characteristic dangerous propensity of lions. For the application, Gary Clark, the director of the Topeka Zoo, testified that 9-month-old cubs are strong, dangerous, cannot be truly tamed, and tend to wrestle and bite in play. Chester's rearing and biting directly aligns with this expert testimony regarding the natural propensities of wild lion cubs. Conclusion: the fourth element is met.
And after analyzing all the elements, what was the court's final conclusion?
The court officially adopted the restatement rule, concluding that strict liability is the appropriate doctrine for wild animal in Kansas, holding the Smiths strictly liable for Chester's actions.
Okay, I really want to cement that utmost care element in your mind, so let's run a gross, unforgettable hypothetical.
Oh boy.
Imagine a neighbor keeps a pet wolverine in a custom-built, triple-reinforced titanium vault. They undergo daily safety checks. But a freak meteor strike cracks the vault, the wolverine escapes, and bites off the mailman's nose. It's absurd. But even though the owner used literal utmost care, the titanium vault, and the escape was a freak accident, the owner is still strictly liable.
Even with the meteor.
Yes, because a wolverine is a wild animal, and biting off noses is a dangerous propensity of that class. The policy here is that if you choose to bring an inherently dangerous wild beast into society, you bear the total risk of its nature, period.
That makes sense. So let's look at the next doctrine. How is liability handled when the plaintiff's side also messes up? If the animal owner is strictly liable, does the negligence of the parents cancel that out?
To figure that out, we look to the general rule for comparative fault in Kansas, found in KSA 60-258A. This rule dictates that all types of fault, regardless of degree or legal theory, whether simple negligence or strict liability, must be compared to apportioned causal responsibility for an accident. Okay, which brings us to the next phase of the case. Because the plaintiff argued that since the Smiths were strictly liable, the parents' and grandparents' fault could only be compared if their conduct was worse than simple negligence. Like if they knowingly and unreasonably subjected the child to risks.
Right, they wanted a higher standard.
Let's analyze Mills v. Smith's comparative fault issue. First, what are the legally dispositive facts?
The trial court instructed the jury to apply comparative negligence based on a definition of simple negligence for the parents and grandparents. The jury then apportioned fault. They gave 40% to the Smiths, 50% to Althea Mills, the mother, and 10% to the Buckbees, the grandparents.
And what was the core legal issue?
Can simple negligence be directly compared to strict liability for the purpose of apportioning fault? Or must the negligent party exhibit a higher degree of culpability?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule of comparative fault, KSA 60-258A. The elements are: first, identify all parties whose fault contributed to the injury. Second, compare all types of fault, regardless of the degree or whether it stems from negligence or strict liability. Third, apportion the causal responsibility and damages based on those exact percentages.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, identifying contributing parties?
The sub-issue is who contributed to the injury. Applying the facts, the Smiths contributed by owning the lion, the mother by being distracted and failing to supervise, and the grandparents by not noticing Darcy approaching the dangerous animal. Conclusion: the element is met because multiple parties contributed.
Understood. Now what about the second element, comparing all types of fault regardless of degree?
The sub-issue is, can the parents' simple negligence be compared to the Smiths' strict liability? For the application, the court explicitly rejected the plaintiff's argument that strict liability is heavier and requires a higher threshold of parental negligence to be compared. Kansas Supreme Court precedent establishes that fault underlying a negligent act must be compared to fault associated with strict liability without requiring a finding of knowing and unreasonable subjection to risk. Conclusion: the element is met, and the trial court correctly refused the plaintiff's special instructions.
And the third element, apportioning responsibility.
The sub-issue is, how are damages affected? Applying the numbers, the jury found $248 in actual damages. Because the Smiths were only 40% at fault, they're only liable for 40% of the damages. Conclusion: the element is met, and the trial court's judgment of $99.20 against the Smiths is mathematically correct.
And after analyzing all the elements, what was the court's final conclusion?
The court affirmed that strict liability torts are fully subject to standard comparative fault principles, meaning a wild animal owner's financial liability can be drastically reduced by the simple carelessness of the victim's guardians.
I want to introduce another memorable scenario to really lock in this comparative fault concept.
That's good.
Imagine someone legally keeps a highly venomous rattlesnake in a secure glass terrarium in their living room. A guest comes over, gets distracted trying to take a selfie, trips over their own untied shoelaces, shatters the glass terrarium with their head, and gets bitten.
Well, applying the rule here, the snake owner is strictly liable for possessing a wild, dangerous animal. But under this Kansas comparative fault rule, the guest's simple negligence tripping over their own shoelaces will be directly compared to the owner's strict liability.
So they just weigh the two against each other.
Exactly. If the jury finds the selfie-taking guest was 90% at fault for the sequence of events, the strict liability payout is slashed to just 10%.
Wow. Okay, let's pivot to the procedural mechanics. Because the plaintiff wasn't happy with the jury blaming the family 60% of the time, how hard is it to take a decision away from a jury or overturn their verdict on appeal?
It is exceptionally hard. The general rules governing these motions are found in Putter v. Bowman. For a directed verdict, the rule has two elements. First, the court must resolve all facts and reasonable inferences in favor of the party against whom the ruling is sought. Second, if reasonable minds could differ, the motion must be denied.
And what about on appeal?
For sufficiency of evidence on appeal, the rule is, first, the appellate court does not weigh evidence or pass on witness credibility. Second, the evidence is viewed in the light most favorable to the successful party below. Third, if that evidence supports the verdict, the court must not intervene.
Let's analyze the procedural aspect of Mills v. Smith. First, what are the legally dispositive facts?
The plaintiff filed a motion for a directed verdict claiming the defendants should be 100% at fault as a matter of law, and later argued on appeal that there was insufficient evidence to support the jury's verdict dividing fault among the family.
And what was the core legal issue?
Did the trial court err in denying the directed verdict, and was the jury's verdict contrary to the evidence?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the standards from Putter v. Bowman. For a directed verdict, first, resolve all inferences favoring the non-moving party. Second, deny if reasonable minds could differ. For sufficiency, first, do not weigh credibility. Second, view evidence favoring the successful party. Third, uphold if supported.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element of the directed verdict standard, resolving inferences?
The sub-issue is how must the facts about the attack be viewed. Applying the rule, the court must look at the facts favoring the Smiths, namely, that Mrs. Smith warned the family, the mother admitted to being distracted, and the grandfather was busy taking a photo while the toddler walked up to a lion from behind. Conclusion. Inferences favor the defendants.
Understood. Now, what about the second element, reasonable minds differing?
The sub-issue is, could a rational jury find the family negligent? For the application, given the testimony about the distractions and the obvious danger of a 100-pound lion, reasonable minds could easily conclude the parents and grandparents failed to exercise ordinary care. Conclusion, the element is met and the directed verdict was properly denied.
In moving to the sufficiency of evidence standard, how did the court apply its elements regarding weighing credibility and viewing evidence favorably?
The sub-issue is, can the appellate court second-guess the jury's 40-50-10 split? Applying the rule, the appellate court refused to reweigh the conflicting testimony about whether a warning was heard or how fast the child ran. Viewing the admitted evidence favorably to the Smiths, there is ample support that the family's simple negligence was a massive contributing factor. Conclusion, the element is met, so the court will not intervene.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded the trial judge correctly submitted the comparative fault issue to the jury, and the final verdict of $99.20 was not contrary to the evidence. The judgment was affirmed.
That is just incredible.
It really is. Now, I want to explicitly synthesize all the rules we've discussed into a step-by-step diagnostic checklist for you to use as an actionable tool for issue spotting on an exam.
That sounds extremely helpful.
So, step 1, identify if a wild animal caused the injury. If yes, trigger restatement section 507, check the elements. Is the defendant the possessor? Was harm done? Remember that utmost care is a red herring. Do not let facts about secure cages or warnings trick you into applying a negligence standard to the owner. Finally, confirm the harm came from a characteristic dangerous propensity, like a lion biting, not a lion transmitting a rare human cold.
Got it. What's next?
Step 2. Scan the fact pattern for comparative fault. Did the plaintiff or a third party contribute to the injury?
Which moves us to step 3.
Right. Step 3. Apply the comparative fault statute, KSA 60-258A. Crucially, recognize that you must compare apples and oranges. Weigh the defendant's strict liability directly against the plaintiff's simple negligence. Apportion damages accordingly.
And the final step?
Step 4. If an exam question asks about overturning the jury's decision, apply the highly deferential procedural standards. Resolve all inferences against the moving party. If there's any room for reasonable minds to differ, the jury's apportionment of fault stands.
Well, thank you for joining this deep dive. Understanding these mechanics really shows how even the most absolute-sounding legal concepts, like strict liability, exist in a web of shared responsibility.
Absolutely.
I want to leave you with a final provocative thought to ponder. If simple negligence can offset strict liability, what happens if the wild animal owner is keeping an endangered species for conservation purposes? Should the law treat a commercial rancher showing off a lion for photos the exact same way it treats a specialized sanctuary trying to save a species from extinction when an accident inevitably happens? Keep analyzing, keep questioning, and we'll see you next time.